This video is intended to provide some additional information about administrative law and also about ethics, which are the subjects of Unit 2 of the course. The legislative branch of government, whether it's federal, state, or local, has the authority to enact laws. But the legislative branch of government does not enforce the laws. So when a law is enacted, unless that law is very simple, the legislative branch that created the law has to assign an existing administrative agency to enforce the law or create a new administrative agency to enforce the law. The portion of the law that either creates or specifies the administrative agency that's responsible for enforcing the law is called enabling legislation. From a constitutional standpoint, the administrative agencies are not given any authority, but the authority that they exercise is delegated to them by the legislative branch that created them through that enabling legislation. For example, the Federal Trade Commission is a federal administrative agency created by the Federal Trade Commission Act of 1914 with the purpose of enforcing prohibitions against deceptive trade practices and unfair methods of competition. Since the United States Congress has a grant of power in the Constitution to regulate interstate commerce, the Federal Trade Commission Act includes enabling legislation that is a delegation of congressional power to regulate interstate commerce to the Federal Trade Commission. In addition, many laws that are enacted by a legislative body, especially at the federal and the state level, are complex, and the details of the law are really something that needs to be worked out by experts rather than the legislative body that created the law. Therefore, in addition to enabling legislation, in creating a new administrative agency or assigning an existing administrative agency to enforce this new law, the legislative body gives that agency rulemaking powers, the power to issue rules and regulations that are necessary to carry the law into effect and to enforce the law. Since the law, since the power to flesh out a law and create the details necessary to make the law effective is possible only through the rulemaking power given to that administrative agency, that rulemaking power is vital, but it's also subject to abuse. So there has to be some restrictions on the rulemaking power. Because the rulemaking power is essentially a delegation of power from the legislative body to the administrative agency, the rules and regulations made by the administrative agency carry the same authority as law as if it was made by the legislative body. But the process of making those rules and regulations have to follow a specific procedure. Some of the rules and regulations that administrative agencies make are called legislative rules. Those are the rules and regulations that specify what the administrative agency is authorized to do, or rather are the rules and regulations that the enabling legislation allows the administrative agency to make. But administrative agencies also often issue interpretive rules which are necessary to explain what the administrative agency believes it's supposed to do and how it interprets various aspects of the law that it's dealing with in a particular situation. Legislative rules have the authority of law. That is, They must be followed just as if they had been included in the original law that was enacted by the legislative body. And those legislative rules, before they can become effective, must be published, if they're at the federal level, must be published in the Federal Register, which is a daily newspaper issued by the federal government that contains all of the rules and regulations of various administrative agencies that are being proposed. The publication of those rules and regulations has to take place over a specified period of time, and anyone who is impacted or will be impacted by those proposed rules and regulations has to have an opportunity to comment on the proposed rules and regulations to the agency that is proposing those rules and regulations, and, if necessary, object to the rules and regulations and call upon the administrative agency issuing the proposed rules and regulations to have hearings about the propriety of those rules and regulations. On the subject of ethics, which is also included in this unit, ethics is about right and wrong, and how a person determines what's right and what's wrong, and how a person should act once they've determined what's right and what's wrong. And while many situations that people face, determining what's right and wrong is pretty straightforward. But not always. Sometimes determining what is right and wrong is not always so easy. And once a person has determined what they think is right and wrong, actually doing something about it can also be difficult. There are many ways, varieties of ways, to divide ethics into component parts. There's virtue ethics that ask what kind of people we should be, and there is action ethics that ask what we should do in specific situations. There's distributive justice that considers the consequence of decisions and actions and how those consequences are distributed among the population, and procedural justice that ask how ethical decisions are made and how actions on those decisions are taken. Another way to consider the component parts of ethics, or to distinguish the different approaches to ethics, is to focus on the most important ethical questions, like how should people act? That's called normative ethics. What do people think is right? That's called descriptive ethics. How do we put ethics into action? That's called applied ethics. And we will consider all of those various approaches to ethics in this unit.